the last one. We are working really hard. I don't want to say we. I want to say, to be honest, Ron Peck is working really hard on our template for 2019, how we're going to formulate the year, what we're going to focus on, what we think every TPA, broker, stop-loss carrier, and self-funded employer needs to focus on for the year as a whole. We'll have that obviously ready to go in January. Folks, today's a very special day. We have a lot to be thankful for this year, as you all know. I think the entire industry does. I've been speaking to various CEOs across the country from all of our clients, and it seems pretty clear to me that most of you, I say a vast majority of you, have had a great year and are looking for even better things in 2019. Renewals are there. You're getting new clients. There's obviously a massive interest in self-funding for brokers, CFOs, from employers as well. So it's a pretty good time in our industry. But I want to make sure I talk about the elephant in the room. For the first time in a long time, as John Jablon just mentioned, we will have no political update today. Our insider, our correspondent from D.C., Brady Bizzarro, everyone's favorite. We get more Save Brady's than we get Save Matt's job, just so you know, Matt. Brady is at the Future Leaders Conference in Tampa. So while we're all here suffering, guys, in 25, 30-degree weather, Brady's right now by the pool, having a nice time, supposedly at a Future Leaders Conference, which I really doubt he's doing much there. What do you guys think? You agree, Ron?
No, I think he's actually being investigated. Being our DC insider, he's been scooped up in the dragnet.
Oh, like with Michael Cohen, you mean?
Exactly. He's being investigated too. He can't be there without it touching you.
It is possible. Folks, in addition, in 2019, I am very honored to say that I will be the chairman of SIA. The torch will officially pass over to me in a couple weeks. So I'm really excited about what we're going to do at SIA in 2019. And one of the two main focus points that I have for my 1-year tenure is one is to re-engage to the TPA market to make sure that SIA is doing everything it can on behalf of the third-party administrators in this country to ensure we're helping them and assisting them in their fight for business, in their fight for profits and prosperity. In addition, as we mentioned a couple seconds ago, the second part of my agenda is to ensure that we get younger as an industry. That's why that Future Leaders Conference, the Future Leaders Agenda, is right on the top of my wish list for the year. Also want to make sure I talk about today who our actual speakers are, now that we don't have Brady. You'll see you got myself. We have Ron E. Peck. Say hello, Ron.
Hello, Ron.
We have John Jablon. Say hello, John.
Hello.
I can't get over this picture, guys. I mean, what is he doing?
He is so sophisticated.
Here's the funny thing, right? Andrew Silverio, folks, if you don't know him, he is not that good looking. Like, he looks really good. I look good, but I look good. It's like, that's a real picture of me. That's not him. That's a Photoshop something. I mean,
yeah, it's airbrushed.
Is it the glasses? Is it the arm movement?
The confidence, Adam. It leaks off the page.
I mean, you would think that he's like ready to take over Hollywood. I mean, the guy looks amazing. Is that the photo you used to get your? Did you meet your wife with that photo? Is that how that happened?
Yeah, that's my online dating photo.
If that was your online dating photo, honestly, you'd be divorced in a week. Because, I mean, I'd call him. I don't even like it. I mean, I'd give this guy a ring. Andrew Severio, say hello, Andrew.
Hello.
Guys, I can't say anything better about what I just said than Andrew. Folks, if you like Andrew, if you think that picture's great, please feel free to send us a quick text and note. I'm already getting a bunch of questions. We're all handsome. I think you're wrong about that. We have one handsome person here. The other three are just okay. Anyways, please, folks, follow us on LinkedIn. Hashtag Save Matt's Job. Folks, he came into my office twice today. Adam, please push LinkedIn. I'm like, what? He's like, you got to talk about LinkedIn. We have to get those numbers up. Folks, if you're not following the Phia Group on LinkedIn, guess what? Here's what I want you to do. Take out your phone and delete your LinkedIn account. It's the only reason I have LinkedIn is because you're following the Phia Group and all the great stories that we have. So please reach out to us because obviously otherwise you won't see all the handsome people that we have working here. You won't see the faces of Phia, which is, I think, another big thing we want to talk about in a couple minutes. Speaking of, Level 3 certification has arrived. We're really excited about it. No one's going to pass it because Ron and I are the ones giving up the test. Next, I want to make sure we give a shout-out to Elaine. How do I say that last name, guys? Anybody?
Holtower.
Holtower? If it's right, Elaine, please send us a quick note that we pronounce your name right. You have been an amazing fan. You listen to all of our webinars. You're on the podcast. Thanks so much for listening. We will make sure Matt sends you out a great package of gifts. We have new pens. We have backpacks. We have great new Columbia fleeces. Wonderful stuff. We're going to make sure we send out a big care package to you. In addition, please go on iTunes and subscribe to our podcast. They are fabulous. They're fun. If you like Joe Rogan, we're better. Okay? And that guy has millions of followers. We only have like a couple hundred, but we're better than that guy, Ron. I promise you.
If you don't like him, we're better than him too.
Recently, we've been talking about the faces of Phia. These are the three recent people we talked about, Joanna, Katie, and Judy. We will be putting their podcast. I think we already have Judy's out there, right? We have Joanna's and Katie's still to publish. But we're going to continue this. This has been a great program that we put in place to make sure that all the people behind the scenes of Phia, not just the handsome Andrew Silverio, get some attention and acknowledgement here at our company. So, with that, here's what we're going to talk about, folks. We're going to talk about last month's most frequently asked questions. We're going to talk about master's degree, what? Appeals, PPO, RBP, and DPC. I love that, right? So what are you guys going to talk about today? PPOs, RBP, and DPC. If you're not in this world, like, what is that?
Death by an acronym. It's the worst.
Specialty drugs, fiduciary concerns, and stop loss and employee handbooks, and then we will be done for the month. So with that, I'm going to turn it over to a fan favorite, John Jablon, to talk about last month's PGC's most frequently asked questions. Take it over, John.
Thank you, Adam. So the first question here, this is relevant to, well, any TPA who's here listening. Our ASA specifically says we're not a fiduciary. Is there anything else we need to do to avoid being considered a fiduciary? Well, excellent question, John. The answer to that is to avoid being a fiduciary, the only thing you can do is not act like a fiduciary. We have preached this probably thousands of times now. We've got our PACE service that specializes in fiduciary transfer. We field consulting issues about fiduciaries all the time. We talk about it on probably every single webinar in the last 3 years. We've mentioned this at some point. If you do fiduciary things, you are a fiduciary. You can write whatever you want in your administrative services agreement. It won't matter. If you do something that is fiduciary in nature, you're going to be considered a fiduciary.
So, folks, earlier today, talking about fiduciary, I received a case from a client where the denial wasn't even in writing.
Yeah.
It was an email denial. And they were asking us, like, what do we do? I'm like, how long ago was that? They go, like, 3 months ago. And I'm like, what do you mean 3 months ago? Yeah, they denied it on the phone, and then they got to give us an email, and it's been 3 months. And I go, so what were you waiting for? They go, we figured they're going to put something in writing. And I go, you might have passed the statute of limitations in regards to appealing this appeal. So again, we're seeing more and more denials. We're seeing more and more questioning of claims. You need to be sure that you transfer that fiduciary duty, or if you are taking it on, folks, make sure you're getting paid well to do it. Keep going, buddy.
All right. Next question. What exactly is direct primary care? This question arises a lot because, again, we talk about direct primary care. We love it. We think it's fantastic. So people email us and they say, hey, you mentioned direct primary care on your webinar, podcast, conference, whatever. What is it? Well, direct primary care is an alternative to the normal way of rendering care. Direct primary care is when a physician charges what's essentially a retainer for visits in a given month or given year or whatever time frame it is. There are no insurance concerns. There's no traditional claims. In general, it's a doctor who says, I will accept a certain amount of money, say $50 a month, for instance, and in exchange for that money per month, you can call me, you can text me, you can visit me any number of times, etc. Obviously, it will all depend on the particular doctor and the particular business model, but direct primary care is a great thing that you can offer to employees or that you can even suggest to employees, and it's incredibly convenient. And I know that Adam and his family use it personally. I'm sure he could give some stories.
Well, quick story. So my uncle Derek just signed up with our DPC doctor, Dr. Tremblay, and even after he signed up, he goes, so like they're going to send he's going to send like bills to my insurance company. I go, no, there's no bill. He's like, wait a second. So you're telling me if I see him 4 times, he gets paid that $80 a month? I'm like, yeah. He goes, that's it? I'm like, yeah, there is no, what most people think of is concierge medicine or VIP doctors where like my mother has, where I pay a flat rate a year or every month for my mother to have access to this doctor. He has less patients than a normal doctor would in a PCP practice. But her doctor, when she sees him, he still bills the insurance company. Okay, MDVIP, I think is the name of it. Okay, this is totally different. It is a per employee per month payment once a month, and that's it. If you don't see him, there's no bill. If you see him 5 times, there's still no bill for his services. Now, if he refers you to do something else, obviously the place he's referring you to might bill you. But for his actual services, it's part of the flat rate. Okay?
All right. So next question, and this is one we get pretty often related to plan drafting and even more related to dealing with actual providers. What are the Affordable Care Act requirements related to coverage of non-network emergency services? So I am the director of our provider relations department, and so it's much more interesting to me the practical effects of this question as it relates to providers than plan documents. So if you're asking this question with relation to plan documents, I urge you to email pgcreferral@phiagroup.com. But here on the last month's FAQ slide, I'm going to talk just for a second about what that means for providers. You see a lot of medical providers that say, this was an emergency service, it was out of network, you have to pay it at the same dollar amount that you would have paid it as if it were in network. That's not true. That is just a bad interpretation of the regulations. What the regulations say is that the cost sharing amount cannot be any greater for non-network emergency services than for network emergency services. So for instance, if you would have paid an in-network emergency claim at 100%, you have to also pay the out-of-network emergency claim at 100%. But 100% of what? It's not 100% of billed charges, well, unless the plan document says it is, but that's a little dangerous. What most plans do is they define their allowed amount based on the maximum allowable charge, based on usual and customary. However you pay out-of-network claims, it's the co-insurance that's relevant to the ACA's requirements, not the actual billed amount. So that affects your allowed amount, not the billed charge. And so that's just a very important thing to remember. So when you get pushback from a provider about non-network emergency services, and when a provider says, the ACA says you have to pay us full bill charges, fight back or contact us is probably an even better option. And then lastly, and this is a question for the ages, are illegal acts exclusions always enforceable? And when does the source of injury rule come into play?
I love the word always.
Right.
Like always.
And nothing is always enforceable.
People
nothing is
like
always out
there. Put the
there.
word in and it's like, okay, we can deny it. It's amazing.
So this question, and again, this is something that we've talked about for years on our webinars, and the reason for that is because it comes up so often. Illegal acts exclusions encompass tons of things. One of the most popular is drunk driving. Some plans have separate exclusions for that, but most plans lump drunk driving into illegal acts, which makes perfect sense because it is an illegal act. Now, of course, it depends on what you put in your plan doc. Do you talk about felonies? Do you talk about misdemeanors? Do you talk about any illegal act? That language is relevant both for the enforceability of the exclusion itself and for stop loss. You're going to face stop loss gaps if you use poor cost containment language with respect to illegal acts. It's not even a question of what the gaps will be or when you might have them. You will have them if your language isn't just as strong as stop loss.
You know, I have a trivia question that I could easily stump half our panel here. Ron, not you because you were part of it. But you guys realize the reason, the first ever issue that we have paid for under Phia Group Consulting, the first time we ever actually charged someone to give a consulting opinion was based on an illegal act exclusion related to drinking and driving. It was almost like it was our number one thing. And the reason why is a lot of drinking and driving cases involve subrogation. So you have a combination of plan doc exclusion plus there's a third party responsible for an injury. So I have really, it makes me think back to 2007, 2008, we first started doing this kind
And
of
it was actually also the origin of our gap review, because that felony versus illegal act issue.
That is true. But it's not the origin of assignment of benefits, which Ron has been talking about since high school.
No, I'm the origin of that.
Speaking of which, talking about high school, a little bit bigger than high school
Good transition.
is the master's degree in health benefit design. Now, obviously, you can't get the master's degree until you actually go to college, but we're really honored that two of the people on our fine panel, the two people on our panel that just don't have the time to do this, because Ron and I obviously don't. Maybe John Jablon won't have the time pretty soon either in a couple weeks. But for the first of its kind offered by the University of Lynchburg, feel free to Google them. contact us if you want more information. There'll be a master's degree being offered. This is what it's going to be talking about. And folks, you see that bullet there where it says Health Benefit Design 1 and 2? Yes, we will be teaching those online courses. The handsome Andrew Silverio will be teaching level 1.
Yes.
And the almost as handsome John Jablon will be teaching level 2.
I'll take it.
It's awesome. We are honored that they reached out to us. The person that designed this program at the University of Lynchburg reached out to us and basically said, based on what I'm hearing, your reputation, you guys should be the ones that should be teaching this course. So we're really excited about that opportunity. If you want more information about it, obviously contact them directly or reach out to us and we can get you that info. Now, talking about nostalgia, let's bring it back to the person who really is the star of our webinars. And I'm not talking about Jen McCormick. By the way, Jen McCormick, is she coming back next month?
She should be.
Because I'll be honest, Ron, John did an okay job, but just like his photo, it's just okay. Jen McCormick does an amazing job on the frequently asked questions. Our numbers skyrocket when she starts talking. With John, they sort of just, stay the same.
Yeah, Jen is the F&A of FAQ. She's the best.
That is true. So speaking of, Ron, let's talk about appeals.
There you go.
Folks, there's a lot to talk about here. Clearly, you deal with appeals real quick before Ron gets into it. When you look at the entire appeals process, most people, in my opinion, most TPAs and their claims management, look at it like, oh, if we have to deal with it, we'll then deal with it.
Yeah.
But there are so many more. I would urge almost every one of you on this call to have not only a detailed appeals process in your plan document, but an actual work process of what you're doing internally. And these are the kinds of questions, Ron, that you want them to address when they're figuring out how they're going to handle it within their organization.
I think that work process is a great term, Adam, and the reason I think it's so relevant is people assume that
And he's not just saying that Summer's boss.
No. I actually agree with you this time. I think that when you look at appeals, the problem is people think about, claim comes in, it's denied, now we have to worry about an appeal. If that's your mindset, where you're waiting for the claim to come in and be denied, you're way behind the 8 ball. The thing is that when you look at an appeal, first of all, you need to make sure from a process standpoint that you actually have or are doing everything required by law. One of the big issues that keep popping up, people ask, if I notify someone that a claim has been denied via an EOB, okay, I use an EOB to tell somebody that claim is denied, and tying back to what you were talking about, Adam, when the notification was by email, right, or by phone, people ask, what is an eligible or a legal notification of adverse benefit determination, which is required by law? And people ask, can I do it through an EOB? And the answer to that question is yes, if the EOB includes all of the details necessary to constitute a legal notification of adverse benefit determination. The problem is EOBs have very limited real estate, and there's such little room for verbiage that usually you can't include enough information in an EOB to constitute a notification of adverse benefit determination. The problem is that doesn't stop people from doing it anyway. And so somebody gets an EOB and it says, denied because, see the plan. And that's it. And it doesn't explain appeal rights. It doesn't go into detail. That's not a legal notification of adverse benefit determination, but that's all they're getting. In the past, people just let it go. Now they're starting to push back. So that has to do with the actual material you're using. The second question is, who gets notification of adverse benefit determination? Question keeps coming up. If a provider receives assignment of benefits, and I promise I won't go into it, are they a beneficiary? Do they have a right to an EOB as well? Or are they only a beneficiary as it relates to payment, not other plan rights? Great question. So these are the issues that pop up before the appeal is even received. Now, let's say we get past all that, you're sending the right notification, you're sending it to the right people, and they file an appeal. How you handle different types of appeals will differ depending on the type of appeal. Pre-service appeal, who's keeping an eye on the clock? Timing is everything. And I got to tell you, you miss a deadline and that provider goes and provides the treatment anyway, they're going to turn around and they're going to say that they determined they basically relied on your delay, your lack of responsiveness to their detriment, that they relied on your lack of responsiveness and assumed it was approval. So again, be careful, keep an eye on the clock. Same thing with urgent care appeals. Post-service appeals, maybe the timing is not as important. Now, basically documenting the appeal, because you have to assume as people start to understand better their rights to file an appeal, to seek an external appeal with an IRO, they're being counseled by attorneys, by the hospital, by providers. Hey, look, make sure you exercise all of your appeal rights. You might as well. Even if you were right in denying the claim, If you didn't properly paper the file, they're going to turn around and say, well, it appears your denial, although it was right, was arbitrary and capricious, which brings in all sorts of fiduciary liability issues. So again, you got to be careful. Other things we're seeing. The ACA requires you to have at least 3 IROs in your Rolodex for external appeal purposes, and yet the number of people we talk to in this industry who don't have the names or contact information for IROs and don't have them contracted baffles me. I got to tell you, if I owned an IRO and the law required you to work with me, I'd be marketing that. Apparently they're not, but whatever.
Yeah, but you know what's one other thing too is not all IROs are the same. I mean, a lot of these companies that do these reviews, the clinical reviews. So as you all know, we do a lot of clinical reviews here because we have to, right? As part of our PACE program. You'll get 5 reviews from 5 different companies. They all might have the same answer, but some have a 1-page document. Others have a 30-page document. You get what you pay for. So please reach out to us if you want to know which IROs are the best ones to work with, because trust me, we've seen them all. And there are certain ones as attorneys, I would not want to use them as my supporting documentation in a courtroom. Where others, I'd be, highlighting them. Your Honor, check this report out. Here's why we denied the claim, or here's why we think it's payable. It's very clear that there's a wide gap in regards to what you get from the different IROs in the company.
Absolutely. And by IRO, of course, we're referring to an independent review organization.
There are no dumb questions.
Yep,
Trust me, just dumb people.
Yeah,
we're just joking. We're kidding.
That's a good line from a teacher. That's good for your master's class. We got to remember that, right?
Yeah,
hands up, hands up. And the last thing I'll mention is, again, folks, we talked about before, being a fiduciary, acting like a fiduciary. Ultimately, it's impossible to escape. If you are receiving appeals and you're making denial determinations, appeal determinations, chances are you're going to be deemed a fiduciary because you're not going back to the plan with every question. And to that point, like Adam said, imagine down the line someone's going to challenge you. You want to be able to prove your decision was based on the plan, your decision was based on evidence, and you made the right decision.
John, just one quick thing to add to this. Some of you may be wondering what actually happens if you don't give a compliant EOB. Ron talked about what needs to be on an EOB and, that some can be far too vague. So what actually happens? What happens is that if the plan offers one appeal, and then it offers another appeal, and then it offers an IRO, if you give a non-compliant explanation of benefits on the first appeal or even on the denial, the internal appeals are exhausted, and the claimant can jump right to a lawsuit. I mean, the whole point of internal appeals and even the IRO is to limit the number of cases that go to the court. The courts don't want to be bogged down with suits by every provider for whom a claim is denied. But if the provider has a claim denied, and then the plan does not do what it's supposed to do, the court wants to hear it.
And that's not good. That's part of the plan. If the court wants to see it, and remember, every court goes out of their way to make sure, have you exhausted all of your administrative processes first? Right. Is the first thing they ask. They go, we don't want you to come here until we know everything you could have done in the normal business process has been dealt with.
Yeah, but Your Honor, they withheld my rights from me. They didn't offer administrative remedies to me. They wanted me to come before you.
All right, we gotta move on from appeals, guys. I know we can talk about this for hours, but no one else wants to hear about it. So what's next, Ron?
So PPO network, status quo. Okay, so here's the deal, right? And we've talked about this ad nauseum in the past, but we want to bring this up again as we talk about what to look for in 2019, because it's going to continue to be an issue, is the fact that, one, networks do charge fees. I got to tell you, it's interesting. We've started to have more open dialogue with providers, health system, hospitals, and it's amazing to see that a lot of their concerns and issues actually mirror our own, one of which being the fees, right? The cost of being part of a network, and do they feel like they're actually getting their money's worth for it? So that's one thing to look at. But the second thing is the juice worth the squeeze? This is interesting because you need to ask yourself, what is the cost of a network in the first place? People think, well, there's a fee, right? There's a fee and I get a discount. Well, there's more than a fee. There are contractual prohibitions on your ability to audit. They limit your ability to steer people towards one in-network facility instead of another, and we'll talk about that in a second. There are these limits on your right to administer the plan in accordance with the plan document, and it also creates legal liability for whomever signed the network contract. And I point out it's a network contract versus the plan because, and here we talk about claims retroactively adjusted by providers past the stop loss payment deadline. And of course, we're talking about where you pay a certain amount, maybe you submit it to stop loss, policy expires 2, 3, 4 years later, someone contacts you on behalf of the hospital and says, hey, we were doing an audit and we noticed 3 years ago you paid us after 32 days, and in order to get the discount, you have to pay within 30 days. So because of those 2 days, we're revoking the discount. We want you to cut a check plus interest. Well, even if you cut them the check, and I don't think you should, but even if you do, you can't submit that to stop loss. So that's pretty scary. In those instances, the knee-jerk reaction that I've seen from my TPA and benefit plan friends is to respond back and say, well, according to the plan, you've missed your appeal deadline, right? Back to appeals. The same response every time from that office representing the hospital. We're not filing an appeal. We don't care about your plan. We are accusing you of breach of contract. What contract? The network contract. Statute of limitations, 3 years, 4 years, 5 years, depending on where you are. So you can take your appeal deadline and you can shove it. That's the response every time. So the fact that you've signed a contract, created that additional contract liability in court, has nothing to do with the plan or plan administration.
Now here's the bottom line, folks. One of the things you need to remember is this. And I'm stealing a little bit of Ron's thunder and our thunder in regards to 2019. But what we noticed is this. If you're a TPA in today's world and all you're offering is a network option, it's probably not good business sense. It doesn't make good from a business sense, and here's why. Brokers are looking for more alternatives than just networks. CFOs of employers are getting much more savvy in relation to employee benefits, where they realize now they can actually do something and make a difference. Why do I bring this up? Look at Blue Cross Blue Shield of North Carolina with their new My Choice program, which is basically a reference-based pricing program that they built for the State Teachers Association, their union, where they're doing RBP. I'm not saying RBP needs to be done by everybody, but you need to have other options other than just network options. Maybe a narrow network, maybe a replacement for a RAF, which Ron's going to talk about. Some carve-out opportunities. You need to have an actual solution for specialty drugs or for all drugs. You need to have cost containment opportunities. Earlier today, there's been recently opioid crisis settlements being made by pharmaceutical companies where they're reimbursing people who purchase certain drugs. Well, is there a subrogation program for that? Do you have a program for that? So every single administrator out there, if your whole game is saying that we have access to a network, sure, it's going to work for some employers, but don't be surprised if clients that have been your clients for 5, 10, 20 years suddenly are no longer your clients because they're being told by their broker or others when they go to a conference that there are new and better solutions out there. Those solutions might not be better, but they're definitely new. And people want to see new stuff. And one thing I want to bring up is what we also have noticed is some of the networks aren't pushing back quite as hard as they used to, because I think when they have their board meetings, guys, when they have their quarterly meetings, they're bringing this stuff up too. I mean, if you're a network, there's no question that you're bringing in the flyer showing, guys, Blue Cross of North Carolina is doing a reference-based pricing program. We're seeing RBP grow. Sure, there's pushback, but we're seeing people at least questioning the status quo. And that's why when you talk about, are you looking to maintain the status quo? Or it's one thing that we're really focused on for the next year is to talk about what those ideas are and bringing those ideas to you to help you succeed in 2019 and years going forward. So, Ron, what can they do right now as this relates?
Yeah, so Adam, what you talked about is that you have to offer different options. And it's funny because when we talked about it this morning, I was actually thinking it's similar to, I think Baskin-Robbins is a local brand, right? Baskin-Robbins is owned by or merged with Dunkin' Donuts, right? They're a local brand. And you know what they're famous for, right? 31 flavors, right? 31 flavors. Chances are 99% of people go in there and they're either buying chocolate or vanilla, right? But people say, oh, let's go there. It's 31 flavors. They've got some flavor of ice cream in the back of the freezer that nobody eats. But the fact is they're still offering it, and it makes them attractive and something they're proud of. So, again, when you look at something like reference-based pricing, maybe it's like the rum raisin of benefit plan services. And we're not going to offer that flavor. Nobody's going to eat it. I get it. But you still have to offer it, because then you can put on your banner 31 flavors, because even if people don't want to take advantage of options, they want to at least have them. That's number one. Number two, maybe rum raisin is too much for most people, but maybe they don't want vanilla anymore, so you go for something that's a little bit more simple.
Why are you talking about ice cream in the middle of the winter?
It's about that's a good point. I'm trying to
what
toppings. There you go. They got anchovies. Nobody wants the anchovies, but at least you can offer the option. People want to have options.
Now I'm thinking about anchovy ice cream.
All right, guys, we're going to get there.
No, but at the same time, guys, don't forget this one, right? Again, I know Cheesecake Factory is a big favorite of people, but I hate that place. And the reason why is the menu's too big. It's almost like New York City. It's just too big. You can't go to every restaurant. You can't order everything at Cheesecake. A 2-page menu is fine. So, when you have too many things, it confuses people.
It's a balancing act. And
Right.
I also think another thing you need to focus on is transition. So it's not just about offering one option that is like the vanilla of benefit plan services. Everybody uses it and is familiar with it. And then the only other thing we offer is some crazy flavor nobody wants, like frosted asparagus or something insane like that. You need to come up with a transition somewhere in the middle of the spectrum. And I know for a long time we've been talking about the spectrum of risk and how much risk you're willing to take on. It's possible that somebody wants to try some reference-based pricing training wheels and attempt to apply reference-based pricing, Medicare Plus, as a pricing methodology only for out-of-network claims to start. And you couple it with a traditional PPO. And then maybe the next year, they shrink the PPO down, narrow network. So now you have a few more out-of-network claims than you did before, and RBP is working for that. And then eventually you pick one center of excellence, you have a direct contract, create steerage, get really great rates with that hospital, and everybody else is out-of-network. And then you say, you know what, I don't even need a direct contract, let's try RBP for all. But the point is, it's a transition. And if you don't offer options that span that spectrum, you're going to lose people.
Right. Because what we often see is, we'll have brokers contact us saying, I have a 20,000 life union plan that has, it's a fully insured, it's a Blue Cross Blue Shield, everything's covered, and we're thinking about just switching everything to reference-based pricing. And I go, next year?
Shell shock.
Right. And I go, so like you said, a baby step oftentimes works. So speaking of reference-based pricing, one of the things I always talk about, and I'm happy that John is going to be talking about this today, is not all reference-based pricing is the same. People assume it's one flavor. It's all vanilla, as Ron is with his ice cream flavors. It's not. It's very different. All reference-based pricing is the only thing that's the same about it is how you're pricing a claim based on some reference point. But how it's done, how it's implemented, what the plan doc looks like, the stop-loss verifications, balance billing verifications are all very different depending on the vendor you use, your internal, what's the word I'm looking for? The amount of goodwill the amount of noise you're willing to deal with.
Your risk tolerance.
With that, John, your thoughts?
Thanks, Adam. That's actually a really great introduction to these particular slides, because on this slide, I'm going to just talk about what reference-based pricing actually is, but right after that, we're going to talk about different types of payment models, and then we're going to talk about different types of RBP vendors. So the first question, and this is a question that we get so often, and this is not a stupid question. This is a very legitimate question.
What is RBP?
What is reference-based pricing? What is it? We see TPAs and brokers, and they have plans that are clamoring to use it. And I can't tell you how many TPAs say, we would love to help you, but we just don't really understand it. We've heard it. We know that other people are using it, but what is it? And for me, the easiest way to explain it is by turning RBP backwards, PBR. And I don't mean Pabst Blue Ribbon beer. What I mean is RBP is reference-based pricing. If you turn it backwards, it's pricing based on a reference. PBR, that is the easiest way to think about it. Instead of paying based on bill charges or based on what other providers charge, you're basing it on a reference. And the most common reference is Medicare, because Medicare is one of the only metrics that is really understood and widely used by the entire industry. So at its core, reference-based pricing is just a way to determine the plan's allowable amount. Redefine UNC. Instead of paying the average of what other providers charge, you pay a percentage of Medicare. It doesn't make the plan particularly different. It doesn't make the plan really special. It's certainly not its own plan type. It's an ordinary plan that just pays different amounts for claims. It's very, very easy to make it much more complicated than it is. But at its core, reference-based pricing is just how much you pay for a given claim. It has no impact on the claims or appeals procedures. Appeals are still intact. Fiduciary duties are still intact. Everything is identical except for the actual dollar amount that the plan pays.
You still have to pay at the same time. You still have the same appeals process. You have the same, everything is, it's just how much you're actually paying that's different.
Right. And of course, there are certain vendors in the industry that help plans with this. Some TPAs do it in-house. There are lots of different ways to do it, and that's what we will talk about in a moment. But as for the actual payment models, as Adam said, there are probably hundreds of combinations of things you can do for reference-based pricing.
Right, so before you start telling us, send us texts, oh, there's more models than this, we know that. We know that there are hundreds of variations, no question about it.
Right.
But we're just trying to keep this simple in the fact that we only have 20 minutes left.
Yeah. Here are some of the most popular ones. Of course, there's the full reference-based pricing, or maybe you call it pure reference-based pricing. No networks whatsoever. No contracts with providers. It's kind of the wild, wild west out there.
And when you say networks, there are facilities claims and provider claims. Both are paid based on reference-based pricing.
Right. This kind of full reference-based pricing models, no contracts with any providers.
Regardless if the bill's $100 or $100,000, no actual contract in place.
For a lot of groups and a lot of TPAs, that's a really scary concept because, of course, there's the prospect of balance billing. I mean, if even physician claims could be balance billed, you could be looking at a lot of pushback. That's why it's really important to ally with a vendor who can help you handle that pushback.
Or at least ally with a broker who knows that.
Absolutely.
Many people have no idea. So when you hear the word, and maybe I'm going ahead of us here, but when you hear, oh, we have 2% of our claims are balance billed. Yeah, but you're only doing semi-RBP or hybrid RBP, right, which you're going to talk about now.
I am, yeah. So the hybrid approach, and this is the one that can really take probably the most forms because hybrid just means it's part of something and part of something else. Maybe you have a narrow network or a physician-only network or even specialty networks like a dialysis-only network, for instance. I mean, we've seen all sorts of networks. In this day and age where everything is in flux in the self-funded industry, vendors and providers are getting really creative. So in this type of approach, because there are some contracts, whatever they may be, fewer claims are getting balance billed.
Right.
But generally, it's the larger claims that might be subject to balance billing, for instance, in a physician-only network, because the contracted claims are the small ones.
The largest hybrid approach that we see is a physician-only network with all facility claims being paid based on a Medicare price. So if you're a sales guy for that company, you're going to say, oh, yeah, our balance bill rate is half of what it would be with this other vendor where they do full RBP. Yeah, well, you only have 1/10 the number of claims, right, but the claims are bigger. So again, really dig deep when you're asking questions to what type of approach that particular vendor is looking for.
And this last bullet here, direct contracts, kind of a subset of the hybrid approach. Direct contracts involves just literally signing contracts with providers. You see a provider who's charging reasonable amounts. You call that provider and you say, let's sign a contract. We know that you're billing reasonably, but we just want to make sure that we have a contract in place to protect members, to protect us, to protect everything. Now, different types of reference-based pricing. We just talked about different payment models, and now we're just going to talk about some different vendor models. Now, these can obviously vary wildly. These, again, as Adam said, these are not the only models, certainly not, but these are some of the main ones. The first one, and this is kind of the most scary, is when the vendor will do repricing and nothing else.
Right. So speaking of that, so people automatically assume, I'm sorry if I take over this slide.
No, not at all.
People automatically assume that everyone can reprice the claim correctly. I thought that. That's not true. I would argue that half the vendors that do this stuff don't even reprice the claims correctly. Some overpay the claim. Some underpay. But the bottom line is I've had a vendor come to me and say, no one reprices better than us. I go, you're right. Wow. It's amazing. I go, so what else you do? They go, the members, they can write the letters. I'm like, dude, that might have worked in 2012. You cannot get away with that today. You need to have something. So the second option is some letters, right, John?
Right. I mean, maybe there's repricing, and maybe they give you a letter template.
You pray to God and hope that no one pushes back.
Right.
Again, we're seeing the first two. You just don't see that much of that anymore. Almost every company has to say that they do, and you'll see the word here, advocacy. Everybody's got to say they have some of it, and then you have balanced billing based on dollar amount thresholds and legal actual defense in a courtroom versus patient advocacy. But I would argue, regardless of what you want to do, the hybrid models, etc., the way to choose the right vendor, folks, is focus on their patient advocacy approach. That's it. Because the bottom line is 99% of these issues can be resolved at the patient advocate level before it goes to court, before it has to be potentially negotiated, before it goes to a legal firm or someone like Phia. Just do your research talk to the vendors you're looking at, talk to the brokers. If you can get the right patient advocacy where there's a very proactive approach, you can definitely find a balanced, a reference-based pricing program that could work for you.
Which brings us to our next slide, manipulation of statistics. This is a slide that at one point Adam called me, and as he does with his calls, he said something unintelligible, but he said add something about manipulation of statistics to the webinar. So what we came up with is realizing that when vendors are selling you their services, they're doing exactly that. They are selling. They're telling you what you want to hear. Your duty as a consumer is to ask questions. Question everything, as that last bullet says. But if they say, oh, we never see balanced bills, why? Is that because your plans pay at 300% of Medicare?
Right. So a good example with Blue Cross Blue Shield of North Carolina. In their documentation they sent out to the facilities, they are actually paying more. So what they did was they looked at their Blue Cross contract and they said, all right, listen, physicians. Under the old model, we're paying you based on a network contract, which was equivalent to 180% of Medicare. Under our Medicare plan, we're actually going to pay you 200% of Medicare. So you would sit there and go, why would you pay the physicians more under this new RBP approach versus the old network approach? And that you won't have any balance billing because they're actually getting paid more money. And the reason is, guys, think about it. All they're trying to do is set a foundation. What they're trying to do is get RBP accepted in the minds of these doctors and these providers and these facilities. What they want is for more and more hospitals and facilitators to agree that a reimbursement based off of a cost-plus scenario is good compared to a discount off a charge. So they know they're actually overpaying just to get the RBP footprint within those facilities. So you're right. If you're overpaying, you're not going to get balanced bills. Or you see a manipulation where maybe you overpay on the providers, but you underpay a little bit when it comes to the facilities where the larger bills might be.
Right. And lastly, there's also an interesting phenomenon where a lot of vendors won't touch a balanced bill unless it's over a certain threshold. And that may be a resources thing, right? Maybe they just don't have the bandwidth to deal with it all. But at the end of the day, it changes the statistics. If they say, oh yeah, we've only dealt with 10 balanced bills in 5 years, well, that's because some of your balanced bills, you're not considering them balanced bills, even though the members are still getting billed.
Also, don't forget, folks, a lot of people, like this reminds me of when I first got out of college and started Phia. I used to get bills in the mail and just throw them out because I knew I couldn't pay them. So one of the big problems with RBP is even though there's no noise, until that person goes to actually buy a car or refinance their home, they don't realize their credit's been dinged because they were throwing out those letters and they weren't even going back to the TPA bringing their documentation. So with that, talking about what happens if you can't resolve claims or if RBP goes bad, we're going to talk about some of the cases, and Andrew, our handsome, fine attorney here, is going to talk about some of the cases across the country right now that are challenging not just repricers, but plans, members, administrators, stop-loss carriers, the entire gamut, and what's going on. Andrew?
Yeah, so like Adam was saying, providers, for as long as we can remember, they have been able to give a quote-unquote advantage to certain payers by giving a larger discount off their bill charges. It's not going to impact your bottom line because you can just boost up those bill charges. RBP takes that power out of their hands, so they hate it. And as John said earlier, we're sort of in the Wild West from a perspective of case law as well as statutory law. There really isn't much yet impacting or governing RBP. It's not super new anymore. Courts and state legislatures even more are super, super slow to catch up to new trends. So we have lots of cases all over the country throwing out all sorts of different legal theories to try to attack RBP.
If you want to talk about any particular case, feel free to contact our legal team about them, but obviously, Andrew, go into some of this as much detail as you can.
Yeah, I won't go into the details of all these specific cases, but some of the legal, off the bat, as you can see, discovery phase, amended complaint filed, preliminary hearings. These are in the early stages. It'll be months, years before we see these.
So just so everyone knows, we here at the Phia Group, we're following every case. I think it's every month, Ron, or every quarter.
Yeah.
We actually update, follow, we have triggers, we have everything. Has anything changed with any case that comes out? Obviously, folks, we want not only to tell you about it, but our internal processes, our internal arguments are going to change based on the outcome, dismissal, victory, whatever might happen from these cases in particular.
Yeah, and every single case is going to be fact specific. So we've got different theories based on breach of contract. That could be a network contract. That could be a breach of contract between the provider and the patient. If your advocacy program is telling patients that they aren't responsible for balanced bills or not to pay them, they're bringing claims based on that. There's toss-ins for, unlawful trade practices, fraud. Sometimes they're based on pre-certification, that sort of thing.
It's the kitchen sink approach.
I love that word. I was just going to use that word.
Yeah.
So, folks, just so you know, if anyone out there is ever looking for what we call the kitchen sink defense, feel free to contact us. We basically take every argument made by anyone defending balanced billing or defending reference-based pricing, and we take up all these cases and we put them into a kitchen sink letter to see what's going to stick. Because, Andrew, what would you guess? There's over 20 different arguments or theories that are being utilized right now by people defending reference-based pricing as a way to make this work?
For sure. Yeah, some of them are just outright silly, but they're doing everything they can and throwing everything out there.
That's good. All right. So, again, these cases are all there. Andrew, direct primary care.
Yeah, so we talked a little bit about direct primary care earlier, the basic model of how it works and how it differs from your traditional fee-for-service approach. So I won't repeat what was said previously too much, but I wanted to just mention my perspective on the way that the different payment model impacts how care is actually provided at the patient level. So we know it's not supposed to work like this. You have your Hippocratic oath, but market forces are powerful. So in a traditional fee-for-service model, providers don't benefit from keeping you healthy. Providers don't make money on healthy people. They make money on sick people. So if you come in to the ER all knocked up and, or I should say, banged up, you wouldn't go to the ER knocked up, and that's a poor choice of words. But they patch you up and send you home and you're back the next day. That's great for them. That's what they want. But if you have a provider receiving a set payment amount to provide care for a set number of people, now they want to keep you healthy. Their business is doing better if they're keeping you healthy because they're providing less care and they're providing higher quality, more efficient care. So we use it here. Everyone who's on the program loves it. The patients love the access to providers. They love the quality of care that they get. And it clarifies and purifies a little bit the motivations behind the way care is provided and the doctor-patient relationship.
So another big thing we have is dealing now with specialty drugs. So one of the areas that we're noticing for 2019 is how to deal with this. It's becoming a bigger and bigger problem. I think we're starting to see some traction into regards to what people are doing when it comes to specialty drugs. The issue that comes up all the time is, can we just exclude them? Obviously, it's the easiest way not to pay a claim, right? Is not to cover it. So, Andrew, thoughts on this?
Yeah, so the full exclusion of specialty drugs is sort of the nuclear option. We've seen it proposed. Plans come to us asking about it. But normally the situation is that you're getting killed by one really, really high-cost individual. And when you're in that situation, the options become very, very limited. So if you get one takeaway from this slide, it's the importance of putting some reasonable limitations in place before you have that high-cost diagnosis that's just killing your plan. Because the HIPAA rules against discrimination really limit what you can do once you have that individual getting that drug. So limitations aimed at a disease versus aimed at the treatment itself, they're going to be viewed differently. For example, excluding a specific Hep C drug, which is the highest cost drug, versus excluding treatment for the disease itself of hepatitis C, or an exclusion for the highest cost drug versus some sort of UR approach where you're going to require that before they use that high cost second level drug, they need to go through the more reasonably priced first level treatment to make sure that's not going to work in a more efficient way.
So again, this is something if you want some ideas on what to do and literally what's illegal to do, please contact our legal team. Andrew, great job. Ron, you've been quiet for a while. Let's bring it back to you.
Yeah, I'm still thinking about ice cream.
We got 10 minutes, Ron. Not even. Let's go.
So we talked previously about whether you may or may not be a fiduciary. Assuming that you are a fiduciary, the question really comes down to, and if you look at everything that we just talked about, it's all about cost containment, right? Proactive things you can do to try and reduce the expenditure by the plan, ways that they're being taken advantage of, and things you can do to avoid it. The question then comes up, as a fiduciary, ultimately, I have a legal responsibility to prudently manage plan assets. All right, I got to make sure I'm protecting the money, right? There's a local accounting firm, their radio commercials always say, don't lose the money, right? That's what it's about, is don't lose the money. The question comes up, do I have a legal obligation to proactively go out there and seek cost containment services, vendors, programs, plan structures, processes to contain costs and protect plan assets? Or is it just that no matter how the plan is structured, whether it's a sieve and it's spending money nonstop or holding on to every penny, I administer the plan as written and just contain costs as the issues come up? And it's a really great question, and I think that ultimately people have really only had their feet held to the fire at a legal level for being a fiduciary. If you do something that's arbitrary and capricious, you're not administering the plan in accordance with its terms, even if the plan itself is structured in such a way it's going to lose money, and there are things it could do proactively to contain costs, and you don't take those steps, you're not necessarily breaching your fiduciary duty. You're only breaching your duty if you do something that is contrary to the terms of the plan, regardless of how poorly written that plan is. However, I will tell you, fiduciary duty aside, I think that as a partner, as an ally in the industry, and as somebody who wants to maintain and grow your business, it does behoove you to look at these cost containment measures, regardless of whether you have a fiduciary duty to do so. And some of the areas that we've talked about today, things like appeals, for instance, it's an opportunity not necessarily to do something in-house, but to identify allies in the industry who can do these things for you, make the introduction. When we say you need to offer options in order to grow your business, it doesn't mean you have to do it all yourself. You have to look at the opportunities to work with others and do things that you necessarily wouldn't want to do yourself.
Speaking of fiduciary duties, one of the big areas where people are dealing with breaches, are getting sued, is when they pick the wrong stop-loss policy or the wrong stop-loss carrier. And we're noticing more and more brokers now placing the stop-loss. So I know it's already December. It might be too late. But for those of you that have not yet signed a contract with a stop-loss carrier for 2019, please, John, what are they supposed to do?
Read the policy.
Oh, you can read the policy. I'm not going to say it. You know what I wanted to say and the amount of time it would take. It's a 10-page policy. Go to the exclusion page. If there's a lot of them, there's probably a problem. If there aren't that many of them, it might be worth looking at. Again, read the policy. Don't just look at the amount of money the policy is costing you. Actually read the policy to know what's covered, what's not. Because what's happening too often is, right now, and Ron, you did a great job earlier this year, you wrote an email to all of our current ICE clients, right, the clients that use for legal services, and you gave them free of charge a document that they can get signed off on if they don't actually place a stop loss. Can you give us a little bit more detail on that?
No. So what we were talking about previously is the fact that, again, status quo, everyone's doing things the same way, things are rolling along. The problem is as employers become more educated and want to take a more active role in selecting and forming their plan and picking their stop loss carrier, they communicate that to the broker. They say, I want more options than the TPA is giving me. The employer and the broker, they do their own research. They come back to the TPA. They say, hey, you gave us options 1, 2, 3. We want to go with number 7. We were going to pick this carrier that we researched on our own. We want to work with them. That's fine and dandy. They sign that policy. But then let's say 6 months in, there's a conflict.
There's a real weird, interesting denial reason.
Yeah, they pay a claim based on a network and the carrier doesn't recognize the network, or if something wasn't paid on time, the definition of payment is different in the policy versus the plan. Point is, now there's this conflict. Now you as a TPA, you're saying, well, that's why I didn't have them as one of the 3 options, you fool. But ultimately, they're still going to look to you and say, well, you should have warned us, or it was your fault this happened in the first place.
So what can that TPA do, Ron?
When they select somebody that's outside your little circle of trust, it's okay to allow them to use it. Just make sure you get something in writing indicating that they are choosing this carrier and they are responsible for any conflicts that arise from this relationship.
So therefore, you as a TPA can't be sued.
That would be nice. That'd be nice.
John, be sued, just hopefully you won't.
You're going to win.
Right. So what are some of the reasons we're noticing more recently? Guys, I know about the PPO one. We all know about the Medicare coding rules. What are the ones that we've recently seen that are just like head scratchers?
Here's my favorite. The stop-loss policy defines usual and customary as an amount that the carrier deems reasonable. Fine. It's totally ambiguous, whatever. Where it gets really scary is that the carrier, with this language, denied a claim, and the plan said, why? What's happening here? And the carrier said, oh, Our version of what's reasonable is 120% of Medicare.
And it's nowhere written in the policy.
Right, nothing.
But they have the right in the policy to decide what's reasonable.
Right. That's one of the reasons that you need to read the policy. If you see anything and you say, oh, I don't know what that means, that's a red flag. If you don't know what it means that the carrier has the right to interpret it in any way the carrier wants. And stop-loss carriers need to save money. Everyone needs to save money. So you can expect carriers to more and more be very diligent in how they're defining terms like that.
And they should be. In addition, stop-loss carriers are doing one thing, right? They're making a bet, okay? If you're a stop-loss carrier, you're going, I want your copy of your plan doc. If you're not following the terms of your plan doc, you should be punished. Listen, I'm offering you stop-loss coverage because I'm thinking you're going to pay claims in pursuant to the terms of your plan. You're not paying the claims in pursuant to the terms of your plan, so why in the world should I reimburse you? I get it. However, there are provisions within a stop-loss contract that regardless, even if you follow every single thing in your plan design perfectly, it doesn't make a difference.
Right. In this particular example where the carrier paid 120% of Medicare without saying that they would, this claim was in-network. The plan had no choice. In fact, the discount was actually very generous. I think the discount was something like 60%. The plan ended up paying 40% of billed charges for its inpatient bill, and the carrier said that's still way too much.
Guys, we're almost out of time. We have, I don't know, it's like 100 questions. We do not have the time to go over all of them. We got a bunch. We want to make sure that someone at Phia will reach out to you in regards to individual questions, or feel free to reach out to us. Tell us what a great job we did on the webinar today. Follow us on LinkedIn. Our next, why do we have to keep saying it's free? Can we change that for next year? Can we stop saying free webinars?
You want to start charging for it?
All of Phia's webinars are always going to be free because we care about the future of self-funding, and that's all that matters. Our next webinar, January 16th, 1 o'clock.
2019, sorry.
2000,
yeah.
Wait, John. Nobody caught that, Ron. Someone's in trouble here. Folks, that is a great photo of us. That is
What a nice day, huh?
December. That is not December.
Note that I look the same as in the original photo.
Yeah, he does not look now. And I'm the guy right in the middle with the big Indian shirt.
I've got all the Phia swag on.
Folks, January 16, 2019 at 1 o'clock, we're going to talk about what you need to have in your plan, in your offerings in 2019. On behalf of Andrew Severio, John Jablon, Matt Payton, our amazing producer, our amazing webinar extraordinaire, and the Ron E. Peck. My name is Adam Russo. Merry Christmas. Happy New Year. Have a great one. We'll see you next year. Thank you.